Next case set for argument is case number 19CA011469. Both parties are present. Each will have typically 15 minutes. We're into the hour, so we'll give the appellant 14 minutes. And you can reserve up to 5 minutes for rebuttal. We've read the briefs and are prepared to proceed if you are.
May it please the court, my name is Gerald Walton. I'm here representing Timothy Holden, who is the appellant in this particular case. We have alleged 3 assignments of error, the first of which was that the trial court abused its discretion and committed clear error of law when it failed to issue a directed verdict as to the plaintiff's claim for invasion of privacy when plaintiff both admitted that the defendant's sole ingress and egress required him to go past the plaintiff's residence a short distance away, and that plaintiff also admitted that defendant had a constitutional right of free movement. And the only evidence that was purportedly of stalking was serial videotaping, which was conducted by the plaintiff. The second argument is that the lower court abused its discretion and committed clear error when it refused to allow the defendant to call the Avon Lake police prosecutor, Mr. Rulebach, to testify as to the dismissal of the underlying charges against the defendant, and he was going to explain the entire procedure, and that was clear to the court. It was made clear in the record. Third assignment of error is that the trial court committed plain error when it failed to curtail the plaintiff's closing argument when he argued that the police decision to charge Mr. Holden with assault demonstrated who was telling the truth, when in fact that is not how the procedure worked, and it's known that it's not how the procedures work, and the argument is totally disingenuous and was not curtailed by the court. The facts of the case start out with an incident which took place at the lower part of the plaintiff's driveway after he said something to the defendant, who was driving by on his bicycle, causing the defendant to come over and say, "What'd you say?" And within a few seconds there was slapping going on, no injuries. There's no medical proof of any injuries which occurred. There was only one independent witness, and one independent witness indicated that this little slap fight was initiated by the plaintiff, not by the defendant. But it did cause the plaintiff to retreat and pull a weapon, a handgun, which he had on his person at the time that he made the statement to the defendant. And he pulled the handgun on the defendant. The defendant stumbled, was obviously shocked, and then proceeded to leave the area. One of the things that I think that is pervasive throughout the course of this whole case was the testimony of Timothy Holden. Timothy Holden, it was explained to the jury, put out to the jury, that between the time of this incident and the time of the trial, Timothy Holden suffered a serious injury. He had a broken bone, which turned into an infection, which put him into a coma, which caused him to have a stroke. And his memory, as he testified, was very sporadic and not good. I will tell you that his testimony was less than what I had hoped. That notwithstanding, I don't think that the jury considered any other testimony because we had introduced testimony of the temporary restraining order full hearing, which resulted in the dismissal of the plaintiff's claim for a for a restraining order after having been given an ex parte. The cause of action for the invasion of privacy should have been given a directed verdict because the plaintiff failed to provide any evidence as to what constituted invasion of privacy in this case. As far as the second cause of action, the Judge Interleague's denial of the opportunity of defendant to bring on Prosecutor Rulebach, that was, I think, one of the very damaging things in this case. Only because there were several police officers who interviewed the people involved in this initial altercation. The one who interviewed the plaintiff did not interview the defendant. However, he issued a complaint which was sent to the prosecutor's office. The officers who interviewed the defendant also wrote a report which was taken and given to the prosecutor's office, and the prosecutor called in the defendant to talk to him about the charges and called in an independent witness. In the city of Avon Lake, the standard practice is that when a police officer is given a statement that has some validity as to whether or not there was a crime committed, he files a complaint which is then reviewed by the prosecutor. None of this was brought before the jury. However, what happened was when we got into the third cause of action, of the plaintiff making disingenuous, not the plaintiff's attorney and plaintiff are the same, one and the same, making disingenuous statements in his closing arguments that the truth must have been the way the plaintiff addressed it because the police officers must have believed it in order to file a complaint, when in fact he knew that this was not how things work in the city of Avon Lake. And had we had the opportunity to explain that a complaint is just a normal thing that comes anytime there's a probable cause that some sort of
Was there anything that prevented you from arguing that
Pardon
to
me?
the jury? Was there anything that prevented you from arguing that to the jury?
There wasn't anything that prevented me from arguing from the jury except that we didn't have any evidence in there. And I didn't think it was proper without having the evidence to argue something, and they didn't see a first-hand source, that being the prosecutor himself.
Now you're at total time 6 minutes left. Did you want to reserve any?
I'll reserve the 6 minutes.
Well, you can reserve up to 5 minutes. So
I'll reserve 5 minutes, and
all right.
I'm having some difficulty here, so I'm
Very
sorry.
good. We'll hear from you later. 5 minutes for rebuttal. And you'll have 15 minutes.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court. I would just briefly like to say that some of what Mr. Walton just stated is not in the record below and should not be considered by the Court. Some of what he stated was a misstatement of the record. Some of it he just made up, quite frankly. I would just like to say that for the record. I would like to address his claims, the defendant's claims of error. The first assignment of error was that the court erred by failing to grant a directed verdict as to the defamation claim. But if you actually look at the defendant's appellate brief, what he's complaining about is that there was the element of actual malice was missing, that there was no proof of actual malice. But as I stated in my brief, actual malice was not an element that I had to prove because I was a private figure, and so that is not an element that I had to prove at all. Moving on to the second assignment of error as to the invasion of privacy. Again, the defendant claims error because he did not get a directed verdict on the invasion of privacy claim. I would just simply say that my testimony during trial and the testimony of other witnesses was more than sufficient to establish the invasion of privacy claim. And again, the standard for directed verdict on appeal is sufficiency of the evidence, not manifest weight of the evidence. In fact, the defendant never once mentions manifest weight of the evidence in his principal brief. And the standard on motion for directed verdict is simply sufficiency of the cause of action. And I submit to the court that there was sufficient evidence from which the jury could find the invasion of privacy. And just so it's clear for the record, I admitted that he had a constitutional right of free movement and that there was, that was the sole means of ingress and egress, simply because that was the fact. I mean, I wasn't going to deny what was true, but that has nothing to do with what he did, what the defendant did to me for 3+ years, where he stopped me. We're not just talking about he left, through the egress, ingress. We're talking about he tried to kill me on my driveway. He sent me a hate letter saying he'd come over and spank me, and he referenced a gun and the fact that I'm gay. The constant daily following me in the car and on foot, the harassing remarks, the beeping when he would drive by my house, the looking in my windows, the loitering in front of my house. It was an entire course of conduct over 3+ years. Certainly that was sufficient for the jury to find invasion of privacy. And one thing Mr. Holden did not understand in his brief is that the jury could believe, they could credit the testimony of a single person, myself, but there were other witnesses who testified whom they could have believed as well. But Mr. Holden does not seem to understand that my testimony alone was sufficient to establish invasion of privacy. The third claim of error by Mr. Holden is that the court did not allow Prosecutor Rubach to testify. This whole error is a sham error. It's a frivolous error because it's premised on Mr. Holden's claim that it was I who introduced the fact that Mr. Holden was charged and that the charge was later dismissed, that it was I who introduced that to the jury during the trial. I did not introduce that. If you look at the transcript, Mr. Walton himself clearly introduced that on 2 separate occasions during his cross-examination of Officer Bringman and during his cross-examination of me. So the whole premise of his assignment of error is false. There was nothing for him to offset because I did not introduce the charge. He himself introduced it. He invited the error, if any. And then on this same issue, I would like to say that I've been an attorney for 20 years and I have actually practiced and represented clients and tried cases. I'm no great attorney and I'm not a judge or anything like that, but I've never seen an occasion where a prosecutor came into a civil case like this. Normally there's some type of civil aspect, civil enforcement, where a prosecutor will come in. This prosecutor voluntarily came in to testify against me, and there's a whole backstory here, which I won't get into, but it was just extraordinary to see this prosecutor come in and want to testify. But the bottom line is, all he would have testified to would have been prosecutorial discretion, which was not relevant. I would like to say one other point, though, and I think that Judge Enderle understood this. The prosecutor would have perjured himself because he was proffered, his testimony was proffered as to, it would be this, and then it later changed to being something, the proffer was to something completely contradictory. So I think the judge understood that not only would his testimony have been irrelevant, prejudicial, and confusing to the jury, but it would have been perjury, outright perjury. And I don't think the judge just simply didn't want to allow that. And then the final claim of error is that I made prejudicial or improper remarks during closing argument. As I did in my brief, if you go through what my remarks actually were, you see that every single remark was either directly supported by the evidence or was a reasonable inference of the evidence. Like I said, I had said that multiple officers responded, that was true, that they interviewed witnesses and observed the scene and took photographs, that was true. Then there was some inferences that I said that they assessed the credibility of witnesses, etc. But the most, so everything that I said in my remarks was true, and therefore it couldn't have, and based on the evidence, and therefore it couldn't have been improper. But I also want to hit at the point that throughout trial, Mr. Walton denigrated the officer's testimony and my testimony as to the investigation after the incident, and I was well within my rights to respond to that, his suggestions that I had fabricated the story and that the officers had simply regurgitated what I had told them. He did have a final claim of error, which is that he should have been granted a new trial, but that encompasses his other errors, so it's really basically the same error that I've already discussed. Unless the court has any questions for me, thank you for listening.
Well, the judge originally was going to allow the prosecutor to testify and then changed his mind, if I recall.
Yes, Your Honor.
Did he state on the record the reason why he changed his mind on that issue?
He didn't state why he had changed his mind, but he did state the reason for ultimately making the decision to exclude, which was that it barely would have been testimony as to prosecutorial discretion.
And that was and that it was irrelevant. Is that what was
Yes.
the basis for his decision?
Yes, Your Honor. Just based on your question, if I may briefly just, it would have sent the case off into a highly prejudicial and very confusing subject matter of this criminal case, because in this criminal case, there was an accusation by the prosecutor, and this was sealed in the record, that I had committed a felony in regard to certain evidence, and that he had sent me a letter stating to that effect, and then I had moved the court to seal that letter because he was outright accusing me of a crime without actually bringing charges against me. And so if he had been allowed to testify as to why he did not proceed with the charge against Mr. Holden, that would have come out, and I would have then been forced to basically attack the prosecutor, his motives, and explain the backstory that I had mentioned earlier to Your Honors about why he had come after me. So it was irrelevant and simply would have confused the jury.
All right, thank you for your argument.
Have a nice day.
Counsel, you have 5 minutes for rebuttal then.
Thank you.
Front, yeah, please. Front. Okay.
I don't need to tell any of you that speculation is significantly different than evidence. Throughout the course of this case, there was a lot of speculation. The plaintiff came up with a note that was obviously a slur on his sexual orientation. No evidence as to who had sent it, only speculation on his part, but he presented it as though it were gospel when he was in court. He presented testimony that all kinds of things came, like my client knocking on the back of his house, everything else. None of this was corroborated. It's pure speculation. What we do know is that...
Hang on for a second, counsel.
Pardon?
Hang on for a minute. If he testified that it happened, that's not speculation. That's a matter of the jury's going to believe him or not believe. Isn't that different than speculation?
He did not specify that that my client did any of this. We don't know whether any of that happened. We just know that my client did not do it. He said it had to have been my client. Now, we do know that before this incident ever took place, and he said that part of my client's motivation in doing what he alleged my client did was that my client had a problem with the skate park. All of the evidence shows that my client had absolutely no interest in the skate park. Nobody in his family ever used the skate park. And the only evidence of any disagreement between the plaintiff and people with the skate park is when he was attacked by a young man not long before this, who was a teenager who was the user of the skate park. He tried to draw some nexus to my client. There wasn't any nexus drawn to my client. Pure speculation. There's a lot of fantasy involved in some of plaintiff's ideas, in my opinion, and how he managed to convince the jury that that was fact, I don't know. I can tell you that when we wanted Mr. Rulebach to testify, we wanted Mr. Rulebach to testify not to what his discretion was and what his discretionary reasons were for not bringing a prosecution. He was going to testify as to what are the procedures once a person is arrested. And he would testify that the arresting officer, if he finds probable cause, files a complaint. Okay? There is no testimony that the arresting officer believed the testimony of the plaintiff. That's not the record. However, in closing argument, he said it must have been the way I told you, meaning the plaintiff, because a police officer believed it, and they're trained in conducting examinations and investigation. The police officer who filed this never talked to my client before filing this, and Mr. Rulebach could have basically shown what the procedure was, and it basically would have undermined and done away with the argument that was advanced in closing argument by the plaintiff. I believe it was disingenuous. To make a statement here that the prosecutor not having been allowed to testify would have perjured himself had he testified is absolutely absurd. Coming in here to state that an officer of the court, Mr. Rulebach, who has no interest in this particular case, would perjure himself for this case is absurd. So I ask you to grant our appeal and permit us to have a new trial where we can have all of the evidence accurately placed into the record and accurately argued. Thank you.
Thank you for the arguments today. Gentlemen, the court will take the matter under advisement, issue a decision in due course, and the clerk of courts will mail each of you a copy of the decision on the day it is released. The opinions are also posted on the Supreme Court of Ohio's website. Thank you both for appearing today.
Thank you, Your Honors.